That is what I would like to make it clear. When we talk about asymmetric information, as we know that Galbraith revised sequence says that the producer sovereignty prevails and consumer sovereignty is a myth, because the manufacturers of goods and services, they really pursue the consumers to buy their products with high pressured advertisement. So hence, largely, he really advocates that the producer sovereignty prevails. And moreover, when we talk about the concepts like unconscionability theory, where one party suffers as a special disadvantage, like distress, transactional incapacity, unfair persuasion, and price ignorance. And we are all aware of that the standard form of contracts, they are of kind of largely monopoly, take it or leave it kind of thing. So the terms and conditions are far reasonable, unfair. If that is the case, the courts really avoid the private agreements. Come to a kind of institutions like in Indian context, like Bureau of Indian Standards. This, in the case of consumer protection for goods and services, Bureau of Indian Standards play a major role as a third-party assurance. So if there is any product purchased by the consumer and if it has ISI mark, what it means? It means the BAs give a guarantee that the quality of the product. But here, there is also a limitation. If I purchase a BAS product and I started using it, and if it is really defect or default, or if it harms, and when really I really would like to climb remedial measures, and when the product goes to the lab, so the lab test says that whether the product is because of the defect or because of misused by the consumer. So they are unable to really say exactly. So there is also limitation in the case of third-party assurance, the role played by Bureau of Indian Standards. And in the case of consumer protection courts, that Consumer Protection Act, basically amendments 93, 2002 and 2019. So all these things really enhancing the scope and empowering the consumer courts in order to provide remedial measures to the consumers. And the related discussion which we had, if anyone is interested, you can really go through the textbook, which it is really mentioned in the screen for further reference. And when we talk about the consumer protection courts or consumer courts, specifically, I want to use this graph. This is related to the cases against the doctors. And if we look at the National Commission and the State Commission of Andhra Pradesh and the District Forum of Nellore in Andhra Pradesh, look at the time taken, consumer favor, and the case pending rate. So largely when we talk about Consumer Protection Act, it really gives a simple redressal, that is one main objective, and speedy redressal, another objective. And the third one is inexpensive. They have amended as a affordable redressal kind of thing. If we look at the indicators which we talk about it, particularly the cases against doctors, if we look at the how many cases gone in favor of consumers, look at in the case of National Commission and the State Commission and the District Forum of Nellore, it is very, very low. And at the same time, when we take about time taken, if even the product requires for test, and the consumer court supposed to dispose the case within 6 months maximum. But if we look at that, the graph, the time taken greater than 180 days in the case of National Commission, State Commission, and the District Forum of Nellore. So what basically is that whether the consumer protection or act, the consumer courts is really fulfilling the objectives of the Consumer Protection Act or not. So in my opinion, they are far from fulfillment of objectives of the CP Act 1986. So this is what my observation in the case of the goods and services when we talk about the consumer protection. So if that is the case, then look at the cyberspace transactions. When we look at the cyberspace transactions, um, basically the information regarding the consumer socio-economic conditions on their market and non-market behavioral patterns, that is IQ, EQ, SQ, all will be generated as a byproduct uh, of the parties' transactions in the cyberspace. And this information will enhance producers' power that they use to rob the rest. Moreover, the personal data sharing to a third party and the cyberspace trespass will have both positive and negative implications. The positive implications, like the cases like medical emergency, and the other one is the warranty contracts when the producer really identify high risk consumers, low risk consumers in order to giving cooling equilibrium based warranty, they can also give the separate equilibrium based warranty. So this kind of positiveness is there, but at the same time, the negative aspects is that the privacy issue. So hence the consumer misperception of risks, especially sensitive data, personal data, will impose irreversible harm. And when we really talk about the where our India is really having the reputation in order to the privacy data protection. So India ranked third worst for the data privacy. And after Russia and China, the India occupies the place. So given this, when we really the look at the data, which it is really based on the um, National Bureau of this data is basically from National Crime Records Bureau. Largely, it is 1 year we have taken 2019. Uh, what here in this table really we would like to talk about is that the data is property of information providers. However, technological advancement like cloud, automation, artificial intelligence, machine learning, and Internet of Things. All these technological developments, and in addition to that, the standard form of contracts really provide incentives to the cyberspace providers to exploit the users' data, and in order to take wealth. It is not make wealth. In order to take wealth, and in turn impose pain and suffering. So, in addition to this, there are jurisdictional problems on technological illiteracy and socio and economic uh, uh, vulnerable groups and inadequate institutional mechanisms. And the most important one is deceptive cyber security infrastructure impedes prevention of cyber violations, and also it reduces providing the redressal measures to the victims of crimes, cyber crimes in India. So here, when we talk about the social vulnerability, like uh, gender, specifically female, children, um, elderly people. And when we talk about economic vulnerability, like lower middle class income groups, and economically weaker sections. And when we talk about the deceptive cybersecurity infrastructure, both software and hardware. So largely we are using it imported ones. And there itself, they really use some kind of technology to steal all types of data from us. So given this, it is very, and moreover, when we talk about the redressal mechanisms like police stations and cybercrime courts, they are unable to provide perfect compensation to the victims. Victims such as even individuals, firms, and even confidential national data also. So when we really look at this in Indian context, the victims of the crimes like computer offenses, obscene, data theft, fraud, cheating, blackmail. Uh, when they approach to police stations and the courts for their redressal, and according to the National Crime Research Bureau, the cases pendency as well as the acquittal rates are very high. So, given this kind of facts and figures, what kind of incentive mechanism we need to develop in order to reduce the cyber crimes in India? And we will take a case study, which it is really happened. The complainant was a regular customer on e-commerce shopping site, jabong.com. On 24th October 2018, uh, there was a call from one number and claimed that he is speaking from Jabong. They had complete information of the customer, like phone numbers, address, card details, even previous purchase orders, all the information. So they really say that, pretend that they are the genuine people from Jabong. Then what basically the message? It is you have won the an assured gift and ask them to purchase 10,000 worth of uh, Jabong products. If you purchase 10,000 worth of Jabong products and a gift is assured, what the gift? If you look at that message, that Apple iPhone, that 64 GB, whatever the list which they have mentioned it. So then the person really asked them to pay 10,000. They really mentioned they have given one account number, not through the website of the Jabong, because the scheme is not yet implemented on the website. So the customer think that it is a digital transaction, hence it is be safe, and payment was made. Once the payment was made, then again there was another call or message stating that, okay, so you have paid, and now in order for the gift, you need to pay the GST. So at that time, the complainant really suspected something is going wrong. Then they have really used the toll-free number of Jabong and called and then inquired about it. Then they realized that they have been dropped. So the complaint was filed in various departments, including the cybercrime department. The fraudster was located in Calcutta, and the victim was from Haryana. And the cyber cell of Haryana is not helping the victim, citing that it is a matter of West Bengal crime cell. And neither did the police do anything, citing lack of knowledge in this regard. So, and later that the Jabong customer data has been stolen, and millions of customers vulnerable to such attacks. So this is really a data stealing case, and there are so many of such things. I am sure we as I think we hope that nobody have this kind of experience. If you have, please also really share it with us. Then the other thing is that cyberbullying. Cyberbullying, basically the rogue money lending apps have ensured predatory behavior and harassments by the lenders resulting in several suicides. The other case is that ransomware attacks and the unrestricted data theft, particularly the ransomware attacks, specifically Haldiram's, the Indian food major suppliers, suffered a ransom attack on its servers, and hackers encrypted all their files, data, applications, and systems. And they have demanded a ransom amount of 750,000 US dollars for restoring the access to their data. So this is what basically really happening in the case of cyberspace. Given this, when we really talk about it, we largely do a lot of research on victim-based research. Why can't we also really look at wrongdoer-centric studies? So why do we need to do it, and what we will get out of it? So when we talk about the wrongdoers, when we do the wrongdoer-centric studies, the wrongdoers that are the root cause of cyber crimes, and hence it would be more valuable to collect data from various wrongdoers for analysis. And this kind of study really would help us to know about how the system engages the culprits to carry out such attacks, and what kind of technology or training the culprits they undergo. And the third, modus operandi of high economic or non-economic damages of cyber crimes. We believe this kind of studies will provide findings and also helps to identify potential wrongdoers. Second, prohibit them from being involved. And third, provide information to policymakers to design institutional mechanism so that that can reduce the growth of such wrongdoers. So what basically we really would like to mention is that no doubt there is a need for the victim-centric studies, but also we also need to look into the wrongdoers centric studies. Then just we also can really mention we also can look at the criminal justice system also. We can look at it because it involves huge costs, as we have mentioned that National Crime Bureau research records really reveals that the acquittal rates and pendency is very high. So in order to really to arrest, convict, and put either imprisonment on fine, it really involves huge infrastructure and takes huge costs. And after doing all these things, if the acquittal rates are very high, then we also need to look at the criminal justice system, how it is really need to be shape up in order to reduce the costs of this cyber crimes. Then when we look at the summary and conclusion part of it, that specifically what we want to say is that the mistrust in the cyberspace domain limits the market and the non-market transactions that impede economic growth and development. Hence, cyberspace with an incentive structure program need to be designed to reduce the parties' market, non-market transaction costs under the knowledge economy in the era of globalization. And here, what we would like to propose in a very simple sense is that one is the Kavit tempter, that is let the buyer beware, and the second one is Kavit vendator, that is let the seller beware. So initially, as we have mentioned, that this cyberspace is really promoting the market, non-market transactions across the world. So hence, the development of the cyberspace providers, the infrastructure, hardware, software, it need to be really developed in full-fledged manner So in the initial stage itself, if we put a lot of curbs on it, then there may be hindrance in the making the advantages of the cyberspace for market, non-market transactions. Hence, what we really would like to say is that in the interim period, it would be advisable to adapt let the buyer beware policy that is covet emptor. This will really provide opportunity to analyze and identify the necessary risks and the vulnerabilities exposed due to the use of the digital platforms. It will in turn also provide feedback to the developmental organizations to fix them and even make them liable. So after once the interim period is really over, then we can adapt. It is advisable to adapt the let the seller beware kind of thing. Then one last point, which last but not least, which I would like to emphasize is that non-monetizability. That is, sometimes the sufferings by the victims can be subject to some phobia and can result in irreparable damage, and it is really having lots of non-monetizable losses. In fact, today's cyber attacks have been more sophisticated and harder to detect and are making our sensitive data more vulnerable than ever. So if this is the case, then we need to go for prohibition is necessary rather than prevention and compensation modes of measures. So this is what really I would like to share it with the August gathering, and these are the acknowledgements, and then thank you. Thank you very much.
Thank you, sir. It was a pleasure to listen to you. Now we'll be taking the questions.
Can I ask a question?
Yeah, please.
It's a very good presentation. Just, sir, I want only, I understand there is asymmetric information per se of from our side, like who are accessing that cyberspace. But I think there is a clear information prevailing from the producer side what they are doing. So I don't know why we, though there is law and everything is there, but why we are not regulating, sir? Still, I'm not getting, sir.
Um, Dr. Hitesh, could you explain it once again, please?
Yes, sir. Yes, sir. So
Yeah.
I was saying that when we access cyberspace, from our side, we don't know what informations are going. Like you have given 2, 3 example, and I think it was shocking example that they have all the information of our when we have purchased one thing. Then adding in due to AI, I think they may have additional information. I don't know. Maybe multiple apps may be also having a partnership, and through that also they may having additional information. So from our side, we are not knowing that what information we are giving after purchasing one good, because I also have experienced similar type of thing. That's why. But from the producer side, they are knowing what they are doing.
Yes.
So there is no asymmetric information per se from their side. So why there is no stringent data protection law, and why not they are being punished like a normal criminal offense? Yeah.
Yeah, as we have really mentioned in the beginning that sharing the personal data of the customers to the third parties and the cyber data trespass. I think, as we have mentioned, also the second point that they're not making wealth, but they're taking wealth. You are right. The people, those who possess the information, they have only money motivation, and one is the transfer of money from one person to other person. That is one. And second one, in which it is more vulnerable, is that even blackmailing, which obscene, specifically the vulnerable groups like women, kind of thing. That is very. I think we can't really have any kind of economic, the value of economic damages for that. Um, that's where the concept of non-monetizability. When we really talk about why there are not having enough incentive mechanism, as we have mentioned that this cyberspace domain, it is very important in the globalization and the knowledge economy thing, in order to have a foster growth of economic growth and development. So we need that. But at the same time, as you rightly mentioned, that we also need to have the protection of the personal information of the customers. So here, as we have mentioned, that one is victim-centric studies, second one is wrongdoer-centric studies, and the third one is the criminal justice system-centric studies. So all these three, there is a need for the research, not both academic and industry and the state, the combining, not individually need to do it. So that will really give us a kind of full information where it is going wrong. Because as we have mentioned also that whatever the cyber which we have used a specific reason that the deceptive cyber security infrastructure, whatever the software we are purchasing, whatever the hardware we are purchasing, it is all from the Western countries. And there itself, they really put some kind of programming, some kind of chip. And by default itself, they can steal the data. So that is where there is a lot of the industry work, academic work, and the state, and it requires collective action, Dr. Hitesh. So in order to have a incentive structure to reduce the cyber crimes. So this is what my opinion.
Thank you, sir. Thank you very much.
Thank you.
Yes, sir. We have a question from Mr. Nayakara Virisha. He asked that how to strengthen the cybernetic governance in the context of growing challenges in cyberspace.
Yeah, I think whatever the discussion which I had with Dr. Hitesh, that will really directly, indirectly will give the same kind of answer. And to be honest, to the person who really raised the question, whatever I have shared, it is not a full-fledged research-based dissemination of information. It is a kind of an idea or a kind of problem which we can really present it and discuss about it, and then to carry out the work. This is the main purpose. And to be honest, even I don't have the precise answers for that question. And when we talk about the governance part, as we have seen that whatever the Information Technology Act 2000 and Amendment 2008, and there is also bill is in place 2019. It is in the Parliament. So the government is also trying its level best to really put some kind of efficient legal rules in order to reduce the cyber crimes and at the same time establish the institutions to implement the legislations. But I think there is a lot of gaps in it, and that is where there is a need for a systematic research, combined research. It is interdisciplinary research, as well as the, as we have mentioned, the academic industry state. all three need to be come together in order to do the research to have a solution for short time, rather than individually doing it and then again collate it and then really understanding that it takes time. This is what my
Thank you, sir, for answering it. Now, do we have any questions? Yes, there's a question from Ms. Krishna Agrawal. She asks that in the case of neural networks, when there is a complete black box, in what form prohibition or prevention will be there when one doesn't know how algorithms are actually working?
Yeah, it is a really tough question. It is really a black box answer also. Yeah, I think that is where we need to really what is that work on it. I think if it is a black box means black box. If there is no data, there is no information. What you get out of it? So you need to crack it like what is that IIT JEE. Okay, so we have to work on that.
Yes, thank you for answering that.
I
I think
cannot answer just it is this thing. I think maybe I will also think about it and then I can come back to it later. And to be, I don't have answer for that. The true answer.
okay, so we got a good point for thinking, I guess.
Yeah.
Yeah, so there are no further questions from attendees. So thank you so much, sir, for
Yeah.
this
Thank you very
session.
much. Thank you, everyone. Okay. Thanks a lot. And then I hope all the people are enjoying the very good sessions. And definitely some good academic endeavor will come out of it. And we look forward to see it. Thank you.
Yeah. So now I would like to invite Professor Ranita Nagar to give a vote of thanks.
Oh, I think, come on. I think this formality is not required. I think just we are all, as Professor Praveen Kulshrestha mentions, that we are part of the team. So I think that's fine. So hello, madam.
Good evening, sir. Thank
Good
you.
evening.
You've been in Chennai. You were in Chennai. You took out time. I'm sure you have other, preoccupations. So very kind of you.
Thank you.
Yeah. And as usual, the conceptual framework that you throw at researchers is both very relevant and important. So Krishna has already asked you a question. She's going to engage with you on that.
Yeah.
And
Some of the questions I couldn't
Yeah.
answer, but I will keep it and then.
so she, I don't know. I think Hitesh sir might say something because just thank you,
Oh,
Hitesh
thank
sir.
you. Thank you, ma'am.
I think it's though it may look like formality, but it's not formality, sir. When you come, it give a different energy to the Center for Law and Economics. I recall 2010 when we started. I think we were not knowing anything in law and economics, and you help us like anything. And I think you are true mentor for, at least for me. I think the way you have guided us to go in the law and economics, I think we will truly in depth to you, sir. And not me. I think my all students and GNLU will always grateful to you. And I find a very natural human being, like you don't care anything and you always is ready to help as and when we have approached to you. And I think in that regard, it's a big thing, sir. It's like sometimes you can't tell every emotions in word, but I think you understand what feelings I want to say. So, sir, thank you very much. And we hope that the same cooperation, same teams, I think continue forever and for long, sir. That's what we pray. Thank you very much, sir.
Dr. Hitesh, to be frank with you, I am getting energy from all of you. Okay, so and thank you for that. Thank you, thank you. And I'm sorry I couldn't able to attend the sessions, and I will talk to you and Madam later. Okay, thanks a lot. Thank you. Thank you. Okay, so can I log off, Dr.
Yes, 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 yes.
Bye, bye, Madam.
Yes. Yeah, Ulen sir has arrived. Good morning. Is it I'm audible, Professor Ulen? You have to mute. You have to mute.
Good evening to you.
Ah.
It's a mystery to me why you're 11 and a half hours ahead of us instead of 11 hours or 12 hours.
Ah.
Do you understand that?
Yeah, I also we were when we were fixing the Kaushik Basu lecture and Oliver Hart lecture. There was difference between your time and like Illinois time and the New York time.
Yes.
And Madam
Yeah.
asked me that why they have a different zone in USA. Like you in USA also you have 2 3 different zones. So I could not understand, but I thought whatever the answer has got from Google, we should go ahead with that.
We have sons who. Hi, Renita. How are you?
I'm well, Professor Ulen. How are you?
I'm very well, thank you. It's a beautiful day here. Sun is shining. It's not very warm, but it's beautiful day.
That's nice. That's
I
nice.
was just about to say to Prashant that we have a son on the East Coast with a family and a son on the West Coast with a family. And the son on the East Coast is 1 hour ahead of us, and the son on the West Coast is 2 hours behind us. So we have to be careful when we call, and if we try to hook up with both families at the same time, we've got a real complex problem. All well there? It's a wonderful looking conference. I haven't had a chance to look at Kaushik's talk yet, but I'll do that this afternoon.
So I understood your question in two parts. I mean, how are things there? If that's the question, then things are on the rise again.
Good, good.
You know, the dominant thing called COVID is on the rise again. And
Oh,
if it is
indeed.
a conference, yeah.
Oh,
And
I'm
if it is
sorry.
a conference, then yeah. If the conference, I mean, you know, thanks to, if we have, you know, professors like Professor Ulen, whose book is Professor Cooter and Ulen's book, which is the first introduction to our students. And now I think the first introduction to students in at least 4 law schools where the paper has been introduced as a core subject.
Good.
Then when we have the author of the first book, not just in India, Yale, Harvard, all of that, conferences, you know, they have an energy of their own and they do well.
Yeah, good.
So,
Good. Is the vaccine not widely distributed in India yet?
No, vaccines are being distributed, and I mean we've actually had a very good sizable you know, count in vaccine if you compare it to the world performance, but our population is very high. That's one question. So I don't know the exact data, what percentage is vaccinated, but the numbers are good, pretty good. But in spite of that, there are a few states that are showing increase. Even Gujarat is one of them. So
I see.
you know, we've again been kind of, you know, there's a talk about a semi lockdown and all of that.
Are you following the British model of? I'm sorry.
How things there? I
Oh,
mean, under
very-
Biden, is it different?
Oh, much, much better. It's,
Yeah.
as you know, this is a complex matter to coordinate. But the Biden administration has cooperated with the states. There's always that problem in the United States,
Yeah.
federal government, state government. But the Biden administration has cooperated with the state governments so well that 100 million people have been vaccinated. That's a third of the population,
Okay.
and that's one, at least one vaccine, which provides 80% of immunity. So that's an impressive achievement in less than 100 days. Biden had promised to get 100 million vaccinations within 100 days, but he's exceeded that. It's less than 100 days. The number of new cases every day is going down significantly. As recently as 2 months ago, it was an astonishing number of I think almost 10,000 new cases a day. And now that's down by half. It's down to 5,000 new cases a day, and continue and going down. I think that one of the issues that may also be true there is that I think once people get the vaccination, they think they're invincible. They think they can go anywhere and do anything. And that may be true. I don't know, but it worries public health officials that they're not going to take care. They're not going to wear masks. They're not going to stay indoors as much as they should. But so far, the trend of new cases and of deaths is down significantly. We still, I think our total deaths are 550,000, which is just an astonishing number. It's the size of a large city in the United States. It's as if St. Louis disappeared. And as you know, I'm not a fan of the previous administration. In fact, I hate it. And I think their maladministration of this is one of the greatest crimes of the early 20th century. But we're doing better.
Brazil is terrible. Brazil is in a terrible state.
I'm sorry, it's what, in a terrible state?
I'm saying Brazil numbers are scary.
They're in a very bad place. Partly because as I understand it, they have a different variant that is somewhat resistant to the existing. Not entirely resistant. I mean, it's appeared in the United States as well, and I think most of the evidence is that the three major vaccines are fairly effective against the Brazilian and South African and English variants. But Brazil, I don't think Brazil is very well organized. It's got a sort of wonderful chaotic state. I hope the key, of course, is vaccination, and I hope if they get that organized, and in some countries the military is doing the organization, because the military is one of the most efficient organizations in the society. Maybe that will help.
Right, Professor. So wishing things turn out for the better for the entire world.
Yeah.
Please permit me to welcome you very warmly on behalf of the Center for Law and Economics.
Thank you.
We'll do the formalities of introducing you, but nobody in India, at least in the law and economics, even students now don't need an introduction as far as you are concerned. But Alankrita, I'll hand it over to you. And yeah.
Okay.
Yes.
Thanks.
Good evening, everyone. We welcome you to the plenary session of the GNLU International Conference on Economic Analysis of Law and Governance. Today, we are honored to have Professor Dr. Thomas Ulen, Research Professor, Swanland Chair Emeritus, University of Illinois College of Law, amidst us. A prolific writer and researcher, Professor Ulen has contributed 4 entries on regulation generally. As a scholar, Professor Ulen examines a variety of issues related to economics, legal scholarship, and legal education. He has recently completed work on 2 new books. He was a member of founding board of directors of the American Law and Economics Association and has served as a member of the editorial board of several professional journals. He is also a co-organizer with Professor Rachel McAdams of the Midwest Law and Economics Association. Sir will be taking the session on the why, the how, and the pitfalls of empirical legal studies. Now the floor is all yours, sir.
Very much. I appreciate it. I'm going to try to share a PowerPoint presentation, but how do I do that? I guess Prashant, I may need your help to.
Yes, sir. So on the bottom of your screen, like
Yeah.
in just the middle, so you can see a tab saying share.
It's not lit up, so I don't know what I've done or not done. Do you want to just run the PowerPoint for me?
I can do that, sir.
That would be wonderful.
Give me a second, sir.
Sure.
Sir, I hope it is visible now.
That's perfect. Thank you, Prashant. Thank you so much. And thank you all for your coming to this talk. I want to begin by thanking Dr. Benita Nagar for her invitation to speak to the International Conference on Economic Analysis of Law and Governance. She's been a marvelous friend to law and economics generally, and to me personally. I'm also very excited to be on the same program with Professors Kaushik Basu and Oliver Hart, 2 scholars whose work I have admired and learned from over the years. It's an honor, and I appreciate it very much. I hope this talk will excite some of you young law and economics scholars to undertake empirical legal studies. My focus today is on empirical legal studies. I'm going to attempt to give you, in about 30 minutes, a very brief introduction to that field in the form of a suggestion of why and how to do empirical legal studies and what pitfalls to be wary of if you undertake empirical legal work. This talk will not qualify as a full sit-down dinner. It will be rather a buffet from which I will sample small plates of just a few dishes. A full explication of empirical legal studies would take hours and hours, or better yet, a full semester class and probably a required empirical study by the students. My desire is not to be comprehensive, but rather to spark an interest in you contributing to empirical legal scholarship. If I've timed this correctly, we'll have 15 minutes for questions at the end of my talk. The why. Legal education has long occupied a distinctive niche in the modern university. It has always been designed to teach students the practicalities of being a lawyer and, in some countries, to be a judge. There are, of course, other fields in the university that focus on practical professional training, medicine, nursing, education, business, and so on. I will not dwell on those other academic disciplines, but just point out to you that what I have to say about legal education applies to those other practically oriented members of the modern university. To be effective teachers of practical skills, law professors have often been practitioners who have given up the day-to-day practice of law or service as a judge in order to share the general lessons they have learned with new generations of students. The emphasis has long been on the practicalities of the law. Such issues as how to guide a client to complete the sale or purchase of a house, or to organize a business enterprise, or to provide meaningful compensation for his or her employees, or to distribute one's assets at death. Legal education's focus on practicalities of the profession has had an important implication regarding legal scholarship. Until relatively recently, law professors concentrated on either of two styles of scholarship. One was focused on improving some aspects of the practice of law or the art of judging. The other was jurisprudential, by which I mean a philosophical inquiry into some aspect of law, such as whether donative promises should have the same presumption of enforceability as bargain promises. One thing that was missing from this body of legal scholarship was empirical work. Almost all of the argumentation was anecdotal, such as an assertion that my experience has been that lawyers who trained at an ABA-approved school were more able than those who learned the law by apprenticing in the office of practicing lawyer. It's an interesting question, but anecdote's not the right way to answer it. Or philosophical. And as we know, philosophy, marvelous field that it is not at all an empirical field. Moreover, no one, or very few to my knowledge, ever raised the absence of empirical legal scholarship as something that needed correcting. This historical model of legal education and legal scholarship began to change with the appearance and rise of law and economics. Next slide, I think, Prasad. The story is complex, but let me strip it to its essentials. In the late 1970s and throughout the 1980s, law and economics imported the substance of microeconomic analysis into the study of the core areas of the law: property, contracts, torts, legal process, crime, business associations, and so on. The project was to use the tools of microeconomic theory to speculate on the efficiency of legal doctrine. And I think that it's fair to say this project was a resounding success. This first phase of law and economics was, in essence, an exercise in replacing the philosophical analysis of the core areas of law with an economic theory analysis of the law. In a sense, it was a translational exercise. The philosophical language of the law was replaced by the language of microeconomic theory. If that was all that had happened in the first stages of law and economics, I don't think that we'd be here today having an international conference on the economic analysis of law and governance. But there is much, much more that law and economics brought to the study of law than simply a new set of terms and ideas for talking about the law. What law and economics, very importantly, brought to the investigation of law was the scientific method. By that, I mean that economics has long been a science that advances by posing hypotheses, thoroughly articulating those hypotheses, gathering relevant data, and confronting those hypotheses with those relevant data to see whether the hypotheses are confirmed or rejected by the data. To give an example, consider the minimum wage. That is a wage for employment that the government establishes as the minimum hourly wage that any employer can pay an employee. Currently, federal law in the United States establishes that minimum wage at $7.25 per hour. States are free to set a higher minimum wage, and many are doing so. My home state of Illinois, for instance, began a process of raising its minimum wage by $1 per hour in 2019 and subsequent years, so that in 2025, Illinois' minimum wage will be $15 per hour. Is that a good thing or a bad thing? The argument between proponents and opponents has been heated. Proponents argue that raising the minimum wage is a good way to increase the income of those at the bottom of the pay scale. Opponents argue that employers will not be willing to pay $15 per hour to low-skilled workers, and that, as a result, low-skilled entry-level workers will have difficulty finding employment. That is, they argue, the higher minimum wage will cause disemployment, and people who have jobs will be fired, and unemployment, inability to get new jobs among the poor and low-skilled. How are we to decide between these two views? Well, we could argue, we could scream at one another, we could fight. But clearly there's a better way. It is to find out by careful empirical work whether the theoretical argument is correct, that a higher minimum wage causes disemployment and unemployment. That's exactly, next slide, please, Prashant. That's exactly what David Card and Alan Kruger, economists at Princeton University, did. This is the book that's mentioned on the slide is a 20th anniversary edition of a book originally published in 1995. I will not bore you by describing the various empirical studies that they did, but I will assure you that Card and Kruger are first-rate scholars, and I think that we can confidently accept their conclusion. And that conclusion is this: there is no empirical evidence that a higher minimum wage causes disemployment or unemployment among low-skilled workers in the United States. Let me conclude this section of the talk by giving you a succinct statement about the importance of empirical legal studies. We spent the first decade or two of law and economics simply rewriting the philosophical analysis of law into the language of microeconomic theory. But now, and going forward, we are and must be doing more than merely articulating hypotheses about the efficiency or efficacy of the law. We need to gather data, analyze it, establish a scholarly consensus about which laws are and are not efficient, and move on to still other hypotheses and empirical studies. Let me turn now to the how of empirical legal studies. In the interest of time, I want to point out just two things on this topic. First, that what we are looking to measure in empirical legal studies is typically elusive. And second, that there is almost always a significant lack of relevant data for the empirical legal study at hand. Let me give you an example to illustrate my first point. Suppose that we're eager to measure the efficiency or efficacy of tort liability. The law and economics argument is clear. Those who might be held liable for a victim's injuries would incorporate those expected liability costs into their decision-making and compare those expected liability costs with the costs of precaution and take precaution if its costs, the costs of precaution, are less than the expected liability costs, and not take precaution if its costs were greater than the expected liability costs. We cannot assume that that's the way the world actually works. We cannot really assume that people and organizations make these calculations in the way that theory presumes that they do. They may not make the calculations, or they may make them badly. They may not be aware of their expected liability costs. They may not pay attention to their insurers and their lawyers who urge them to take care. That is, the tort liability system may not be working as we hypothesize that it is. There may be too many accidents, or the accidents that occur may be more serious than they should be. So these questions demonstrate that we need to do empirical work to find out if the tort liability system is working well or ill. How are we to do this empirical work? First, and this will be obvious to economists, but not so much so to lawyers, we cannot look at court cases to learn much. Court cases are a biased sample. Our best estimate is that only about 3% of all controversies result in a court case that goes to a judgment or verdict. That means that 97% of controversies do not result in a judgment or verdict. They're settled or dropped or disposed of in some other way. But even more importantly, we're not so interested in accidents that did occur, although there is some information there that is useful. We are interested in the accidents that did not occur, or that were less injurious than they would have been, but for the existence of tort liability. To find out the efficiency or efficacy of a legal rule, we need to have evidence that doesn't easily exist, evidence of things that did not happen. How can we get that evidence? A common method of doing so is to look for some change in the law and to see if, controlling for all other factors that might affect legal decision-making, there is any discernible difference in behavior after the legal change by comparison to what occurred before. Two last matters. I said earlier that one of the problems with doing empirical legal studies is the scarcity of legal data. This is a significant problem, and it's one that I hope some of you will undertake to correct. Here are two examples. Consider the governmental taking of private property. We spend some time in our text talking about whether that governmental power makes economic sense. And our answer is, yes, it does. It makes economic sense for governments to have that power, but to exercise it only in circumstances in which the transaction costs of assembling land for a major project, such as a national park or an international airport, are so high that governments will not provide some goods, public goods, unless they can reduce those transactions by taking, as the phrase has it, private property, paying fair compensation, of course. That's a hypothesis. Is it borne out by a confrontation with the facts of when and how governments take private property? I don't know. And to my knowledge, there has been only one study of that issue, and that study was done more than 40 years ago. I've asked lawyers in my hometown, in Chicago, in the state government, and in the national government, how often their government takes private property, and whether those circumstances bear out the economic hypothesis of takings efficiency. No one knows. Even in my relatively small town, with a population of 100,000, no lawyer can tell me how many takings there are per year, and whether they've gone up or down over time, whether they involve large parcels of land or small parcels of land. Now broaden the inquiry slightly. How many commercial contracts are entered into in a year in Champaign, Illinois? Is that number going up or down over time? How many of those commercial contracts result in a controversy? How many are successfully completed to the satisfaction of both parties? No one knows. If I had the time and energy, I would undertake for cities, counties, states, and the federal government in the United States to collect data on all these legal matters. And I hope that you will undertake to do the same thing in your countries. We need those data. One last thing I want to raise about the how of doing empirical legal studies. Please be very sensitive to the audience you're trying to reach with your empirical research. If the audience is a public body, such as an administrative agency, a judicial panel, or the legislature, you will be addressing an audience that is likely to know very little about data gathering and analysis. Be careful how you write or speak to them. I can almost guarantee you that they will not read your work. If you are lucky, a staffer will have read your work. If you're making a presentation, use lots of visual aids, easily read and understood charts and tables and maps. Your audience is going to be cautious about interpreting your work, being fearful of being tricked or of not knowing what questions they ought to be asking you. Finally, do not present your work as definitive. There are weaknesses in every empirical work. Be honest, be transparent, point out those weaknesses, help them to see the strengths and the weaknesses of your data and of your conclusions. Finally, the pitfalls, and I'll try to be brief. The problems of doing empirical work are many. And here, as in the previous section, I'll focus on only two issues: the time that empirical work takes and the possibility of fraud, and what you can do to minimize it. First, please be aware of the fact that empirical legal scholarship is very time-consuming. You have to find relevant data for the issue that you're investigating. Those data may be incomplete, or they may be non-existent, or they may be proprietary, so that you can only access them if you pay for them and agree to the owner's conditions for the use of the data. The data that you need may not exist. You will have to find those data or generate them through a survey or an online experiment. Surveys and online experiments are a fine source of data, but they require care in their design. Ideally, you will also have to do a pilot study of a survey or an online experiment to learn what is right and what is wrong with your questions. Let me make some suggestions about how to deal with this time intensity of empirical legal studies. First, be cautious about undertaking empirical work very early in your scholarly career. If your position is not secure, then your chances of securing your position through tenure or something like tenure, your colleagues may require you to have a greater output of scholarship than you are likely to have if you undertake just empirical work. Second, you should consider taking on a co-author or two to help you with the burdens of empirical work. If one of those co-authors knows statistics, so much the better. If the co-author is a lawyer and you're an economist, that's a good combination too. Finally, please be aware of the fact that the time pressures of the scholarly life and of completing empirical work may create a temptation to cut corners, to do a less than thorough job. In the rare, but alas, case that exists, there may be a strong temptation to make up data. I know that sounds unlikely, and that none of you imagines that you would do such a thing. But unfortunately, it happens. It has happened in the law. I commend to you an article by my friend Jim Lindgren entitled Fall from Grace, Arming America and the Belial Scandal. Belial is the name of the person about whom he writes. This is a story of Jim's interaction with the author of a history prize winning book, Michael Belial, a professor then at Emory University. Jim was eager to do a follow-up study of Belial's book about gun ownership in American history. Belial claimed to have examined probate records from the late 18th century through the early 20th century to establish his hypothesis that gun ownership was very widespread in early American history. Jim called him on the phone to ask if he could use his data. Belial was evasive. Then he claimed in a later phone call that he had stored all of his data in his basement and that his basement had flooded during a recent rainstorm. All of his data had been destroyed, he said. Jim then asked if there were archives where he might find the original data. Belial made up some archive names that did not contain the data that he said he used. In the end, Jim concluded that Belial had made up all of his data. The award that his book had won was taken away. Emory University fired Belial. He has not worked in the academy in any university since the early 21st century. It's a cautionary and horrible story. So how do you protect yourself against the embarrassment that Michael Belial endured? First, keep a journal of your research. I cannot stress how important this is. Mark down exactly what you did on the project each day, which data you used, where it came from. If you manipulated the data, make a record of that. If data were missing, note that and what you did to correct for it, and so on. You may think that you'll remember everything you did during a research project, but you won't. Remember, I said that empirical legal studies is very time consuming. It could take 2 years or more. You may not remember what you did exactly 2 years ago, but if you can consult your lab journal, you can tell somebody who asks. And please, please keep electronic copies of your data. Many journals now require you to submit your data along with your writing. Thank you so much for your, for your attention. I'd be happy to hear your reactions and questions and comments.
Thank you so much, sir. That was really an informative presentation. And now we'll take the questions.
Can I ask question? If
Sure.
yeah, so it was a very nice, it was very nice presentation, and it was throwing a light that now world is moved toward the empirical, and though doctrinal have their viewpoint, but if you give empirical evidence, that make a different. You don't have to tell through word, but I think data will tell you what the conclusion can be. Uh, 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 but still, if I go with because I'm crazy with the data part, and I'm doing many courses also, and Ranita madam know that I'm working quite hard in data analysis. But what I feel that sometimes you get in the problem of if you go with, I got addicted with data things. So if you go too much toward data things and without not going concrete theoretical framework. Sorry, my son is this.
Go ahead. I've got nothing but time. Ah, There's a very important piece of data.
Sorry. So what I was saying that sometimes you unnecessarily get in the trap of data thing, and you sometimes you compromise with your, though public ethic is there, but sometimes you do compromise with the too much, not
Yeah.
going through the theoretical framework and just going unnecessary from the data part. Yeah, that's what I want to say. I'm just telling my own experience. I don't know how far maybe other may have maybe have different of opinion. Yeah.
You're absolutely right, Prashant. Dealing with data is not. It's a frustrating experience sometimes. The data are incomplete. They're not exactly addressed at what you want. You're suspicious, perhaps, of whoever collected the data. All I can tell you is to, as I'm sure you're doing, be as careful as you possibly can. And if you manipulate the data, if you, as they say, interpolate, for example, data, that is, imagine what the data might have been between two dates for which there are no data. Just be honest and open with your audience. That's all you can do. The clear norm in the professions that use data is to be as transparent and as open as you possibly can. One last point about this. I think it's that messiness of data that should make a young scholar cautious about undertaking empirical work. It's complicated. It takes a long time, and you can work at it for 2 years and find out at the end that you don't get very exciting results. And one thing I can assure you is that journals like to publish exciting results. They don't like to publish unexciting results.
Thank you, sir. Thank you.
How old was that data point that showed up there?
3 years old.
Yeah, he's a cutie.
Thank you.
Do we have any further questions?
Yeah,
If no, yeah.
I would like to ask
Yes,
Alankrita.
ma'am, please. Yes, ma'am, please.
Professor Ulen, so I've done my bit in trying to, trying to bring home the fact that legal studies, have more impact and accuracy if done through an empirical lens, empirical context. But sometimes I wonder, would sufficient evolutionary understanding, sufficient historical understanding, sufficient understanding of the patterns, the patterns of a system, would that not sufficiently give us answers?
Yeah. Go ahead.
I mean, yes, agreed that it makes it more, the outcomes become a more materially real because you can see the interplay happening rather than just a lot of words. But there is something, one are bare facts, which we call data. Second is mere argumentation. And third is, I don't know whether we can, give it a light touch of the idea of real knowledge,
Yeah.
I don't know if that's scientific or not.
Well,
But to
it's
my
a,
mind,
it,
it
it,
is because many a times, you know, after reading a very exciting paper, something comes to your mind and saying that, hey, this was, I mean, you know, this I mean, maybe not in numbers and percentage change and responsiveness and rate of change, and maybe not all of that, but the general idea, you know, is something that would be quite obvious if there is a sufficient background clarity about history, economics, political science, patterns, you know. I don't know, that comes to my mind sometimes.
well, if I can, I don't want to suggest that the only data that are important are quantitative data gathered in a systematic way. I agree with you that a careful historical study of how we got to where we are is tremendously important, because there's what the best historians do is point out the movements that are occurring, and knowledge about what movements have occurred to bring us to where we are today is important about predicting where we're going to be tomorrow and in the years ahead. Another, I think you're suggesting this, Renita. Another important, I've had this discussion with some dear friends who are sociologists who don't like the fact that social science loves quantitative data. They say they refer, I think, to the sort of data that you're discussing as qualitative data. And I recognize that qualitative data, for example, looking at the life of a particular judge, I'll just make this up, looking at the life of a particular judge helps us to understand something about the law. No question about that. There may not be quantitative data that's important about that judge's life, but reading about that judge's life can give some very important lessons about the law. I'm in favor of anything, any form of data, not just systematic data that's in a spreadsheet that tells us something about the law. And I think the burden is always on the scholar to demonstrate exactly how it is that his or her conclusions follow from whatever data that they have is. Here's the last thing I wanted to say to you. I have observed my colleagues at the law school. I'm an economist, obviously. I have observed my colleagues at the law school over 35, now 40 years. They are very skeptical of people who come to give talks in law and economics. They are skeptical of people who come and give talks from law and psychology, unless those people have some empirical evidence to present. And I'm talking about lawyers. The lawyers love the empirical evidence. They may not be able to do it themselves, but they always sit up and pay attention. And they're bright enough to recognize some possible mistakes or shortcomings of the empirical study, but they always pay close attention. So I think if part of the task of what we're doing is to persuade others who are skeptical of law and economics that what we're doing is an important exercise in making the law a better thing, then anything we can do to get their attention is worthwhile. And if it turns out that getting their attention, a very important way of getting their attention is to present empirical studies, let's do more of it.
Professor, for sure, it drives the frontiers of knowledge. I mean, there's no two ways about it.
Yeah.
But when the world has gone into this, you know, hyper mode of data,
yeah,
and both quality and quantitative, questions come up on so many things. I mean, you know,
Right.
manufacturing of the data,
Yeah, I agree.
quality of the data, and if it's not sufficiently engaged with historical patterns and so on and so forth, that might be another question in itself.
Yeah, exactly.
Because we've gone into this hyper mode, you know.
You're absolutely right. I agree with you. I'm unaware of the fact that big data, so-called, has affected legal studies, but maybe it has. But that's an important study. There are some shortcomings of big data, but that's a subject for a different story, a different conference that you're probably thinking of organizing already.
And also data is, I mean, we agree, except that the authentic source of data are the government sources. I don't know whether that's empirically correct. Is that
Well,
empirically?
it's an important issue. Whenever I've presented data to a public body, an administrative agency, a conference of judges, the first thing they always ask me is, where did these data come from? And the second question is, who paid for this? And clearly, the reason they ask who paid for this is they believe that who pays the pipers?
It's obvious, it's clear. There is an interest.
Sure, of course.
So,
Well, you know, if your study is provided by funds from the Tobacco Institute, and you happen to find that tobacco smoking is not harmful,
cancer disappears.
Yeah, exactly. Exactly.
Thank you, Professor. On this another time. Thank you.
Yeah,
if there are any other questions.
There's a question in the chat that I'll address very quickly. Let me see who sent this.
Yes, sir. Actually, there are two questions. I'll read them out for you.
Okay.
The first question is from Nayakara Virisha. He asked that how to streamline the elements of conflict between economic and legal approach. Do we have the necessary methodological tools and techniques to study the economic analysis of laws apart from Robert Pertner, Gary Pecker's foundations?
I'll be personal. I'll try to tell you an anecdote. When I first went to the law school to teach in 1982, long time ago, I found that one of the most valuable things I could do to get people to pay attention to law and economics generally was to form personal relationships with my colleagues who were lawyers. The older lawyers always had coffee every morning together at 10 o'clock. And one morning I happened to walk into the faculty lounge to get a cup of coffee at about 10 o'clock. And they all said, come on over here and join us. And I became a regular of that group. And we didn't talk about law and economics every day, and we didn't talk about it every week. We'd talk about other public issues. But over time, they asked me questions. I answered them to their satisfaction. That's an important point. And I formed wonderful relationships with those older scholars. And I think that had a very important effect in the acceptance of law and economics among traditional lawyers who were very skeptical. They're skeptical of everything, not just the economics. And having that personal relationship, I think it's probably true in a lot of different aspects of life. Having that personal relationship is a tremendously important part of communicating new ideas to people who otherwise might be skeptical of what you have to say.
Yes, sir. That was an interesting anecdote and you explained it quite well. And So the second question I would like to pose is from Krishna Agarwal. She asked that if there is no data available and at the same time there is no change in law or the law is in nascent stage, then how can one go for empirical studies? For example, in the case of AI, empirical studies is needed. But what data can we collect when no such concrete law has been formed?
That's a great question. Let me give you two examples. First of all, there has been some relationship between AI and the law, in the United States at least. And there have been some studies exploring the effects of that AI. What I have in mind is a study done by Sendil Mulanathan, who you probably know is a very distinguished economist at Harvard, who did a study of the use of AI to decide who would get bail in criminal cases in courts in New York City. I think you have the institution of bail, don't you? Do you know what that is? Bail is somebody accused of a crime is sometimes allowed to offer a sum of money. The more serious the crime, the larger that sum of money is sometimes offered the possibility to leave a sum of money as a token that he will be back or she will be back to face the charges. And if they flee, that money is forfeit. The issue had arisen as to whether judges or an AI algorithm was a better decider of who should have bail. And Sendil Mulanathan and his colleagues studied whether AI or a judge did a better job of deciding who should have bail. And guess what? AI won. That's one thing I want to draw your attention to. And that's not the only study. If you'll write to me at thomas.ulen@gmail.com, I'll give you some other studies because I'm organizing a conference on this topic. The other thing I'd say to you about not having data available is there's a common problem in the law. And the best thing I can suggest for you to do is to do a survey or do an online experiment. There are many very good studies that use online experimentation that can be done very, very inexpensively to try out different scenarios. For example, contracts that have liquidated damages clauses compared with contracts that don't have liquidated damages clauses to see if people feel differently about those two situations and if they would behave differently if a controversy arises in the conclusion of the contract. Tess Wilkinson Ryan, TESS, Wilkinson-Ryan, RYAN, at the University of Pennsylvania has done several of these studies, and they're a model of how to go about doing that. And I'm afraid we're going to have a lot. I'm not afraid. These are good studies. But I think online studies and surveys are a great way to make up for the fact that we do not have a lot of data yet in the law.
Thank you, sir. Now, do we have any other question? Okay, so this brings us to the end of this session. I would like to invite Pranita ma'am for the vote of thanks.
Thank you, Alankrita.
I have had my privilege of speaking to Professor Ulen, at this instance. So I will request Dr. Hitesh to please do the honors.
So good morning, sir. And I think we got a different energy thinking. And surely the participants who are participating, I think they will surely would like to work on the empirical research. And I think your lecture always give us something new insight towards understanding law and the empirical dimension. So I'm really thankful to you for your valuable lectures, and I think you always ignite us. You make us that that GNLU, and at least in India, we do something meaningfully law and economics research. On that note, sir, we are really thankful to you, and we wish you your good health, and we want to see you in GNLU as and when the situation get normal. So as per your convenience, as per your schedule, if things get fine, we would love to have you in GNLU. Would like to host you, sir. Thank you very much, sir. Thank you.
I would
Thank you very much, sir.
Thank you, Hitesh. It was a wonderful opportunity. I appreciate it. Thank you very much.
Thank you, Professor. Be
Thank-
well, be safe, and we'll connect again. Thank you, Professor.
Same
Have a
to
great
all.
day.
Be well.
Thank you everyone for attending this session. We'll end it
Thank you,
here.
Alankrita. Alankrita, thank you.
Yes, ma'am, it was a pleasure. I hope I did it well.
Oh, yes, you did.
You're
Oh, yes.
excellent,
You did.
Alankrita. You are excellent.
Yeah.
Thank you,
so
sir.
much.